the time set for the informational hearing of the Senate Committee on the Judiciary. The topic being the state of data privacy protection, exploring the California Consumer Privacy Act and its European counterpart, known as GDPR. And I should remember what that stands for, but at the moment it is escaping me. It is the European counterpart to our CCPA, which set the way to start addressing the whole issue of data privacy and how critically important it is here in California. As well as, I think, the nation. As they look to California, we are often referred to as the state that shows what is possible. And hopefully in this one we're leading the way. I know there are several other states actually that have in fact taken the model and are using it as a template for their efforts to try to address this problem. There are several members of our committee who are hoping to attend. We do have our Vice Chair with us today, and Senator Monning just walked in. There should be more people coming. We have a robust hearings scheduled. We also have, for any people who are interested in, I won't say it's a quick read, but an important read done dealing with the current state of our data privacy protection, a wonderful comparison between the CCPA and the GDPR that's available here and on the Judiciary Committee website, and I commend it to you. It's not bedtime reading per se, but it's important reading that will give you, I think, some very, very helpful background and understanding of the laws that exist and some of the issues that we will be discussing at some length here this afternoon. Well, you know, I was thinking, who was it in the Congress who was the tax specialist who got himself in a little trouble jumping into one of the ponds in Washington, D.C., Mills, wasn't a name, who claimed that he read the tax code in the evening before bedtime, and that always made me wonder just how much of it he could read when some of it is kind of complicated, as this issue is, but it's an important issue and one that hopefully we will be able to address thoughtfully and effectively going forward. So with that, I'm grateful to all who are here today, and this is also being presented online. As I mentioned, it's an informational hearing, and it's one that I think will be helpful to us in the future. Is Amanda here, by the way? I want to introduce Amanda Matson. She's just recently joined our committee as counsel. Welcome, Amanda. We look forward to some very interesting challenges going forward this year. And what I'd like to do is just make a few opening remarks and ask others if they'd like to make some as well, and then get started. We will have, as I mentioned, some robust discussions, and then we will at the end offer public comment, 2 minutes each, please, with your name and affiliation being provided at the front end of your remarks. So with that, I want to thank the staff again for an excellent series of documents that will be helpful in putting together what I think is a very thorough and exciting panel. This is an important issue and not a new issue for many of us. Privacy and consumer protection have always been very important to me. I think it's after I read the book Brave New World, and the image of a big TV screen on the wall. If any of you have read the book, there is Big Brother who is watching you rather than you watching the TV. And in many respects, this whole issue of data privacy really does have, as part of its consequence, who is watching us and what is the information they're collecting. Now, it may not be the government, or it may, but certainly we do know that the private sector, through the technologies that exist today, have really taken advantage of being able, if you will, to get into our homes, into our lives, and obtain information that many of us don't even know is being taken, and using it or selling it or doing things with it that we're not aware of. And so part of, I think, the challenge has been the public doesn't really know what happens when you go onto the internet or you buy a certain product or something that is identifiable to you, or a product that people might at some point want to sell you, or information about your political perspectives that they might want to use to their own advantage. I think of Cambridge Analytica as an example where we've learned that, in fact, our election decisions, among the most personal decisions we make, were being manipulated as a result of information being obtained without our knowledge, permission, or consent. So California, unlike many other places, and certainly unlike our federal constitution, we have a right of privacy that is built right into our Constitution. And it happened, ironically, we did a little research on this, about 40 years ago. Then Assembly member, then Mayor of San Francisco, and the victim of an assassination was the Mayor George Moscone. And back 40 years ago, he realized that the technologies that were being developed might very well impact our personal privacy. And as a result, was the moving force on a ballot initiative that passed. Do we know the numbers, how overwhelmingly it passed? Well, regardless, it passed, the people of California passed an initiative that put privacy as a fundamental right that exists right within our state's constitution. But despite its status as a fundamental right, our privacy has, in fact, been under attack. And as I mentioned, the Cambridge Analytica scandal, among others, proved that we have lost a lot of our privacy and want to take it back. And last year, we took our first steps with the California Consumer Privacy Act as a result of the commitment, determination, and pocketbook of one Alistair McTaggart, who will be our first witness today, who also, I think, shared that concern about the threats to our democratic institutions as a result of this this loss of our privacy. But the CCPA was a good first step, likely with more needing to be done to bolster its protections for consumers and their privacy. And there are many of us, I think there are something like 40 bills that have been introduced this year addressing the CCPA and other privacy rights. So I think there are others who share my concern that we need to perhaps do more work before we put this bill before the public. Insofar as implementation, it has an implementation period of 2020, so there's work we can do between now and then. And basically, our privacy rights cannot be undermined in the name of corporate profit. I think that is a clear value that most of us have, and certainly one that we're hoping to advance in the years to come off the great work that was done last year, and thanks to Mr. McTaggart. So there are, we know, numerous groups that are eyeing this effort with an interest in diluting its impact. I think many of us here believe that we need to do more, but we want to do it in a way that's workable for our businesses. So part of the discussion today is going to be finding out from practitioners exactly how this bill can be implemented and how the GDPR, which was perhaps a more robust European model, is already being implemented. So the notion we can't do this because it'll blow up the business model, I think, is a sort of a false narrative, and one that I'm hoping we will debunk fairly quickly. We really do need to move forward in this direction. And with that, I will invite others to make opening remarks if they have a few thoughts they'd like to share. Mr. Vice Chair, you're all set to go.
Thank you, Madam Chair. I wasn't planning on having an opening remark, but I will say that this appears at first blush to be a terribly complicated area of the law, one that I'm exposing myself to and trying to learn as much about. I had a community meeting in my former capacity as a county supervisor where we had it was oriented towards seniors, how to avoid senior scams. And that kind of brought to the fore how information can be put out into the public domain, and by those who have ulterior motives can be used to hassle and mislead vulnerable portions of our community, in this case, seniors. and that kind of got me thinking about what is out there. I'd like to make certain that there is an implementation that is balanced, as you mentioned, Madam Chair, that is looking after our constitutionally protected rights based on personal information, while also making certain that we do not so silo our economy, information economy, that hurts us competitively. So I think, like anything else, there's the balance, and I think that approach is always a healthy one. But I would, when I first came to the Senate 8 weeks ago, and I had a Wikipedia page, and much to my chagrin, my birth date was on there. I thought at some point in time there was certain information that was sacrosanct. Social Security numbers, birth dates, truly hallmark identifying pieces of information, and apparently it was out there, and I had to go through the laborious process of getting it removed. It can be done, but the onus certainly was on me. So it was a learning experience. So I'm looking forward to seeing how the CCPA plays itself out in our role in this process.
Thank you. Any other comments? Opening remarks, Senator Allen?
Just because you got it removed doesn't mean one of us can't find it within a minute. Just because you got it removed doesn't mean one of us can't find it within a minute or two, because once it's up, it's always up.
Thank you. Senator Monning.
Thank you, Madam Chair. I'm sorry I missed some of the opening comments of others. I just wanted to, again, thank your staff for what I think was really a helpful briefing backgrounder. I found it very useful. I want to thank Mr. McTaggart and all the witnesses who are here today, and defer back to the chair. Thank you.
Senator Wachowski, any comments, or ready to rock and roll? I do want to tell you just a bit of irony. My husband, who is a retired judge, is listening from home and sent me a text that said the name I was thinking of was Wilbur Mills. So technology does have some place here. Congressman Wilbur Mills. And that may be somewhat problematic. All right, very good. Thank you again, Mr. McTaggart. Really, really appreciate your effort, the work that you have done on behalf of California's consumers. And the floor is yours to give us an overview on the California Consumer Privacy Act.
Great. Well, thank you so much, Madam Chair, Vice Chair, members of the committee, for this opportunity. I really am grateful for this time. It's a privilege and an honor to be here, so thank you very much. What I'm going to do today is just talk a little bit about the history briefly, and then address some of the more commonly percolating myths about it, and address what I've come to learn is called FUD, the fear, uncertainty, and doubt that is being sown around this act, and then to explain some of the critical elements of CCPA. So just a good reminder for all of us to think about some of the technologies that are eliciting so much passion right now. Really quickly, geofencing. You can draw an invisible line around any building, any location in the country, and track every single smartphone going in and out, keep track of them, ostensibly to advertise. In-home devices know everything that's going on in your home, including if they tell you whether they have a microphone in them or not, whether they're recording you or not. Apps, we just saw 2 weeks ago an article in the Wall Street Journal where women trying to get pregnant are putting their most intimate details of their life into this app, and within seconds of them putting the information into the app, the information was being transmitted to Facebook unbeknownst to them. They didn't even have to have a Facebook account for that. The potential for voting manipulation is high. You know, cars are essentially data, gathering machines on wheels now. They know if you go to the gym, if you go to a fast food restaurant, what time you get to work, what time you leave. And as this information has a tremendous amount of value. And as I like to say, 100 years ago, Standard Oil was the most powerful corporation on the planet, but Standard Oil didn't know everything about you. So what was the timeline? I got this idea around the end of 2015. I spent 2 years researching it, talking to as many experts in academia, advocates in business as I could. That resulted in filing the initiative in November of 2017 and starting to gather signatures at the beginning of last year. Through April and June, I started having negotiations with this body, primarily with Senator Hertzberg and Assemblymember Chow. though eventually, you know, I talked to a lot of people, and it took a lot of assistance. It wouldn't have happened, I think, if the chair had not been gracious enough to put her weight behind it as well. You know, as I think about it, it's, you know, one of the things to think about is when we were gathering signatures, we ended up collecting more signatures than people live in either Vermont or Wyoming. This was a very popular issue. We never polled below 80%. Californians really care about their privacy. There was an opposition committee formed. I just put this up just, I do think it's an amazing American story. You know, the amount of money raised against us between the companies that contributed directly to us, to the committee against us, and representing the associations. It was over $6 trillion in market cap arrayed against essentially one individual, which is really sort of a tribute to America, California, that it worked, that this was the result. And many of you were there. That day was a day I won't soon forget that you were presiding, Madam Chair, and the fact that it was bipartisan and unanimous, to me, is a real indication of where this state is at. So what did we actually do? The three main elements of CCPA. One is the right to know what information has been collected about you. We call that the right to know. The second is the right to say no to the sale of that information to hundreds of companies you've never heard of. That's a right. That's an opt-out right. And then the third is the right to have your information kept safe. In an era of identity theft, that's a really important right. So let's address some of the myths. One of these myths is that it came together in a week, and you know, who the heck is Alistair McTaggart to think he's a privacy expert? He hasn't spent 20 years working in this space. Well, in fact, I did take 2 years of research to try to talk to as many people as I could. But the other thing is, we built in many ways on the work of experts that had come before us. So yes, I hadn't spent 20 years researching it, but I can read. And there were a lot of great ideas out there. So I'm going to give you one little case study of one very central part of our law. There is this effort called Do Not Track, which you may have heard of. And it started about 10 years ago. W3C stands for the World Wide Web Consortium. And they took a group of true computer experts at the intersection of privacy and technology who came up with this idea that your browser should be able to indicate to companies whether you want to be tracked or not. So it was a good idea. It worked technically. The problem was it was based on, it was voluntary. And so some companies honored it, some did not. The advertising industry generally resisted it. And as a result, it kind of ended up failing. But national experts had worked on this for almost a decade, this DNT, Do Not Track. And here's a list, I think it's a partial list of some of the, for people in this business, these are kind of bold-faced names with respect to the people at the intersection of privacy and technology. Full disclosure, I got this off the internet, so if people are on it who don't want to be, I apologize. And if people who aren't on it think they should, again, I apologize. Now, the next slide I want to bring up is, don't read it because it's too hard to read all the words, but what I want to show you is that the bold underlined parts, this is from our definition of business purpose, are all drawn directly from Do Not Track. So again, we were building on the work of experts that have been working on this problem for a decade. Our definition of third party, again, very central to our law. The bold underlined parts are drawn directly from Do Not Track. So again, one of the messages here is that this thing didn't come together in a week. It took me 2 years. And by the way, we relied on experts who had gone before. Now, another area that's gotten some attention is, who's covered by CCPA? So we only cover business, not nonprofits, not government. And our idea was, let's go where the problem is. And we think the problem is with big business and data brokers. So we have these 3 thresholds: 25 million in revenue for a company, or a company that collects 50,000 pieces of information a year, or data brokers that get over half of their revenue from selling information. Now, the 50,000 pieces of information has gotten some attention and gotten some criticism because people say, well, if you have a small little blog and you're collecting only 137 pieces, visitors a day, you could hit that 50,000 threshold. And our answer is, okay, but it depends what you're collecting from people. If you're just collecting an IP address, you can't actually identify the person visiting because multiple people can have one IP address. So in our law, we say, look, a business isn't obligated to provide that information back if you can't identify the person with certainty. So an IP address alone would not be personal information. That said, if you're collecting 50,000 people's credit cards and financial information, then indeed that is personal information under the law. Now, whether that's the right number or not. In the initiative, we had a higher threshold. We had 100,000. And in the initiative, we had it just if you were selling information. In the law, the legislature, in its wisdom, reduced it to 50,000 and its collection. But nevertheless, that's a question for this committee. But the point is, it depends what you're doing with the information. Now let's turn to opt-in versus opt-out. And this is a pretty central part of the law. So let's think about the EU. The chair referenced GDPR, which came into effect last May. So GDPR is opt-in. It's based on what's called notice and consent. And if you've been on a European website, you've seen the little pop-up, how about now? Can we collect, we're going to set a cookie, how about now, how about now? We think there's some problems with opt-in. There's some operational issues. One is sort of this consent fatigue. It's kind of a clunky experience. You get these pop-up all the time saying, how about now, all the rest. The second is there is an element of take it or leave it. You know, if you need to use Uber, Uber needs to know your credit card, it needs to know where you're going, it needs to collect your information. There's sort of this like, well, I want to use Uber, but they need to be able to collect my information. So the fact that they're going to ask me if they can collect my information may not mean as much. I know there's a lot of efforts underway in Europe to kind of refine this, but there's an element to that we don't think gives so much control to the customer. And then there's this innovation chill aspect where you're more likely to give consent to a company you've heard of to collect your information than one you've never heard of. So a brand new company, and Europe doesn't have our sort of $25 million threshold, might have a problem. So we thought there were some operational issues to opt in. In addition, when we were doing the research, I was talking to as many experts as I could, and some experts advised me, hey, look, if you go to opt in, you might have this problem with the American legal system and the First Amendment rights of corporations. And because this is a judiciary committee, I think it's appropriate. I'm going to get a little detailed here, but essentially, there's a case that I was advised about called Sorrell versus IMS Health. It's a Vermont data case where Vermont passed a law restricting pharmacies' ability to sell prescriber identifying information to drug marketing companies. And the drug marketing companies took it to the Supreme Court and actually won, and the law was thrown out. And what's really interesting here is I actually just going to put some language from the decision that a restriction on disclosure is a regulation of speech. The sale of information is disclosure for profit. And if the acts of disclosing and publishing information don't constitute speech, it's hard to imagine what does. So the advice I got was, you know, it's not dispositive, it's not 100%, but, you know, you put a blanket restriction on the rights of corporations to collect information, you may be running into this issue where you have a restriction of the First Amendment rights of corporations. Now contrast that with the do not call framework. Now do not call was also the subject of multiple lawsuits, and you all remember you could put your name on a list and say, I don't want to be contacted by telemarketers anymore. This was also challenged. This ended up being a 10th Circuit decision that actually was appealed to the Supreme Court, and the Supreme Court didn't agree to hear it. And this decision basically ended up saying, look, if you're giving consumers a right, that's fundamentally different. That's not trampling on the First Amendment rights of corporations because you're giving the consumer a right to go do something with respect to a corporation. So that's another reason why opt-out seemed a safer bet. You know, I was going to spend all this money. I didn't want to spend all this money and then end up in a court fight and lose. And then the final reason why we think opt-out really makes sense is because what's the experience going to be like for the consumer? So you want to be able to tell a corporation not to sell your information. How do you do that? We require that companies put a do not sell my information button that you can click. But you can kind of imagine that might be a little bit clunky. You always have to click that as well. So what we require is that companies have to honor a third-party opt-out request. Now, what does that mean in real life? In real life, I've gone and talked to the browser companies, and they said, well, look, we were doing this for do not track. Of course, if it's a law, we'll do this. We would put a browser extension into everybody's browser, allow you to set it once and forget it. Now, every visit to every website you make, the browser for you will just indicate to that website, don't sell my information. So what have we done? We've achieved do not track through legislation. All that work that those experts did for over a decade, we've essentially achieved do not track by another route. And we think that's a really momentous step for this law. We think that that is the end of the large companies tracking you across the web. And what I really like about it as a business person is I think it's simple for consumers. You don't have to do very much. Once you just set that in your browser and forget it. Let's now move to advertising, which also has been a little bit contentious in the sense that we permit advertising. The law permits advertising. And, you know, there have been people who've been concerned about that because they say, well, they can track you through ads, and then what are you doing? You haven't really done much. And the point is, well, if we don't permit advertising, we kind of do wreck the internet. So you've got to have some kind of balance. But to go back to your point is, where's the balance? So where we drew the line is we said, okay, you can do the ads, but you can't resell the information. So a little quick tutorial. When you see an ad online, that means your personal information has been, at that moment, auctioned off in what's called a real-time bid to hundreds or thousands of companies. Every time you see an ad, whether you click on it or not. And in many cases, sometimes most cases, that information is retained by the winning bidder and the losing bidders, which is how your information just gets propagated just by just being on the internet. So what our law would say is, sure, you can still conduct the auction, but the information essentially stops. It dies at the recipient. The losing bidders can't retain it, can't reuse it, can't resell it. And so, again, we were trying to strike this balance that you were alluding to earlier. How do you permit commerce, but actually put some reasonable limits on what can happen to the information? Additional rights under CCPA. We give the consumer the right to delete information they've posted. That has to work with the First Amendment, so there's not a European right to be forgotten because that won't work in this country. We increase protection for children. So the age of opt-in is increased from 13 to 16. Having just spent all that time on opt-out, you might be saying, what's all this about? But it is because children are treated differently, so that they're more of a protected class. And then companies, we say that companies can't discriminate against you if you say no to the sale of your data. So you can't all of a sudden say no to your cell phone company, please don't sell my data, and get a $300 a month charge, you know, on your cell phone, which would essentially coerce everybody into saying yes to the sale of their data. Enforcement has been a hot button. AG enforces the act. We have a private right of action, so consumers can sue for negligent data breaches. And what those are there are 3 safe harbors. If a company has encrypted the data, if they redacted, that means took your name out of the data set, or if there were reasonable security procedures in place to protect the data, then there's safe harbors from the private right of action. Otherwise, there's a private right of action for data breach. Essentially, the reason for that is I didn't want to have a situation where a company's doing its level best to comply, and then the Russian government or the North Koreans, you know, hack into the company and there's some liability. So as long as you're doing your best, and essentially if you encrypt it, you're fine, which you should be doing anyway if you're collecting people's information. With respect to AG enforcement, it's gotten a little attention recently. What I would say is this was part of essentially the deal that came together. In our initiative, we had a private right of action for everything, and we reduced it to just the negligent data breach. But we got a lot in return. We got the right to see actual information. The initiative had just had the right to see categories. We got the right to delete. We got the opt-in age increase. So it was a deal. We did a deal between, we reduced the scope of the private right of action and got better protection for kids, for consumers. I would do it again. I think it was the right thing to do at the time. I still think it's the right thing to do. With respect to changes, people have asked me about changes, and you know, this is the committee that will decide. I'm just a individual, and so many have asked me, you know, am I worried about where the law stands now, and is this now time for business to come back in and gut it, and you know, do you feel like a fool? And what I say is absolutely totally on the opposite. In my travels, having met the people who the laws, you know, in whose hands the law rests now, I feel even better about having done it, and I would do it again in a heartbeat, because I feel like the people I've encountered really want to make this the best law for the state going forward. And of course, there are going to be changes, and I'm not some, you know, diehard who says, you know, these things came down from Mount Sinai. You know, I'm willing to, if anybody wants my opinion, I'm willing to give it to. So I'm going to close here with where I think CCPA is in a historical context. If you think about the rise of the auto safety movement in the 1950s, you know, by that point, cars had been mass-produced for 40 years on production lines, and safety really hadn't gone anywhere until, you know, unsafe at any speed and Nader, and all of a sudden people were like, oh, maybe we should pay attention to safety. If you think of the rise of tobacco and anti-smoking efforts in the 60s, you know, cigarettes have been mass produced for 80 years by then. This is an established technology. If you think about, you know, auto emissions and trying to get cleaner air in the 70s, this state obviously took the lead, and people were tired of not being able to see across Los Angeles. And if you think about all three of those examples, in all three of those examples, we the people, acting through our representatives, said, hey, you know, this isn't acceptable anymore. This is an established technology, but you, industry, can and should do better. You need to do better. And at first, industry resisted in all those cases, you know, vociferously. But now just try to imagine selling a car without seatbelts or without an airbag. You know, it's impossible to imagine. And guess what? Business made plenty of money along the way. And it survived and it thrived. And I think we're in such a situation right now with respect to privacy. I think that California is now a worldwide leader in privacy. The feds may or may not do something. They may or may not preempt. Other states may or may not pass. But today, 1 in 8 Americans is covered by this law, which goes into effect next year. And I think there's an awesome responsibility in this room in your hands, because we are at the where this state is so often in the vanguard of really important societal changes. And actually, this is frankly international. I mean, we're a country. We're the 5th largest economy in the world. It's entirely appropriate that we're here. There's a tremendous amount of technical talent and political talent around the room, and I'm humbled to be part of this. And I want to say again, thank you so much for your time.
Thank you again for your work in this effort. It really was one person kind of stepping up in an issue that many of us have found to be, the more we've known, frustrating. And I want to again emphasize the incident that you just referenced. 2 weeks ago, we learned that women who were trying to perhaps get pregnant and putting information into their Fitbits that described their menstrual cycle so that they'd know when they were ovulating, that Facebook would get that information without anyone's knowledge or permission is quite extraordinary. And I think an example of some of the more outrageous but still existing potentials. I mean, I think about it, if you don't want your mother to know you're trying to get pregnant, you certainly don't want somebody who's a complete stranger to have that information either. And this is the kind of thing that we are seeing. So your efforts really have, I think, made an extraordinary difference, and I want to thank you publicly for doing that. I do have one question. And I realize that this was a white knuckle, and both a knuckle and white knuckle effort, because to get those industries, the $6 trillion worth of opposition to come to the table and to resolve this before the initiative was quite an effort. But I wonder if you could share with us what more you think needs to be done to effectuate your intent, recognizing there were compromises made. But if you were, as I often ask, the master of the universe, what would you do more to effectuate your intent?
Well, you know, I think the part that was sort of the most painful for me giving up was the whistleblower. We had a whistleblower provision in that. And that was hard because I felt like sometimes deep in the bowels of these companies, it's going to be hard to figure out what's going on, and you're going to need someone sophisticated to take a chance. So that's kind of an area, I think. I think that there are some clarifications that could be made. Like, for example, I know Household's gotten a lot of press because Household was put in at the last minute. It wasn't in our initiative. There's some real reasons that it needs to be addressed, but at the same time, it does need a definition. So there's things like that. So I think there's some clarifying areas. But honestly, I mean, I will say that the odd circumstance of the having that initiative and having something where the companies understood that this was polling at 80%, and they understood that to get 80 down to 50 was going to cost, A, a tremendous amount of money, but B, was going to require them to be spending money against their own customers, something their customers cared about. They knew that was kind of untenable. So it was an odd dynamic, which I don't think would exist in other initiative situations. And so we did have quite a lot of power to sort of say this is the way it's going to be. And we ended up, I think, with a great law.
Thank you. I will start with Mr. Vice Chair and then Senator Money.
Thank you, Madam Chair. I kind of want to ask you a question. Is your information, from a legal standpoint, as far as you're aware, who owns your information? Is that a private ownership? Is it a proprietary, or at what point does it become public domain? Are you familiar with any case law that articulates when your information is your own and ownership transfers upon a series of events?
I'm going to answer that, and I'm going to look back at my lawyer just to make sure. James Harrison's here if you want to come up with an answer as well. But in the meantime, I did ask the chair if it was okay if he came up.
No problem.
His name is Mr. Harrison, James Harrison. But what I'll answer for now is, you know, one of the issues that we encountered is when we talked about, one of our ideas was to make it a property right, and the issue there is we ran into advocates who said, oh, you can't make it a property right because you can alienate a property right, and this should be something akin to a civil right that you can't alienate, right? But my understanding is, at this point, that the companies own your data, which feels weird, doesn't it? Like, it feels weird that you would give all that information to them and then they own it. I don't know if do you know any case law?
I'm not familiar with any case law. One of the challenges we encountered in drafting the measure is how to deal with information, some of which is voluntarily posted, sometimes with restrictions, such as if you limit your Facebook settings just to your friends, sometimes without any restrictions at all. And once information enters the public domain, it's very difficult to attach any sort of property right to it.
So it's clear this is the Wild West area of the law, because it's not clear as I'm aware of it. Now, going back to the do not call list, was that a national clearinghouse or was that a state? What was?
So what my understanding, and I did some research on it, was that it was state by state initially, and the states did it, and then I think eventually there was a national, but it started with the states, and as I believe that mainstream marketing was a state case.
So in your odyssey of pursuing this, did you contemplate that maybe a clearinghouse style at the state level would take away all the uncertainties for those that don't want to participate in the information exchanging technology, akin to a do not call list?
We did, and frankly, one of the things we were doing was, when we were doing the initiative, we were trying to craft something that would survive without any obvious vectors of attack against it. And so the idea of creating like an agency or something was going to
clearinghouse
take some money, and we knew that that would be something for the opponents to be like, oh, you're just trying to build an agency, so they could maybe attack us on that. So we were trying to get something that essentially carried its own weight. So that's honestly why we didn't pursue that route.
Okay.
Would you do me a favor? Would you identify yourself for,
Yes,
for the record?
I'm James Harrison from Remcho Johansson and Purcell.
Thank you. Thank you.
And my last question is, because I'll give you a quick example. You've heard of Alexa. So we have an Alexa speaker at my house. Well, my kid's name happens to be Aleko. You can imagine the problems that we have when I'm yelling at my kid and Alexa says something in response. So it makes for some interesting dialogue in the house. But in terms of jurisdiction, given that we have essentially interstate commerce situations here where entities are located in different parts of the nation or abroad, transactions are completed in the United States, how does the jurisdictional authority issue play out if there is a opt-out or even an opt-in with entities that are located outside or even internationally? How would they just simply be in violation of California law?
Well, I'll let James talk to more of the details, but essentially, since we give California consumer rights, that's anybody doing business in California has to give the California consumer their rights, and I'll let you talk about interstate commerce.
Right. To address that issue, the law includes an exception to ensure that if a transaction occurs entirely outside of California, even if it involves a California resident, so that the business that obtains the California resident's information obtains it when that resident is out of state, sells it in a transaction to another company that's also out of state. That is expressly excluded from the scope of this law to avoid a Commerce Clause challenge.
Thank you.
Thank you. Senator Monning.
Thank you, Madam Chair. I want to thank Mr. McTaggart for your work on this, particularly your collaboration with the legislature to achieve what you outlined and is now law or soon to be law in California. On this last point, is there any way to protect a California resident consumer using their computer out of state? You raised the concern of the Commerce Clause. Moving forward, is there some way we could look at that and buttress the right of a traveling California resident?
It's certainly something that could be pursued further. I think in most instances there will be some contact with the state of California. I think it would be unlikely that you would have too many instances in which the entire transaction takes place out of the state of California and there's no contact between that business and the state of California. But it's something that the committee could certainly pursue further. Thank you. So in the area of auto emissions, Mr. McTaggart showed us some of our legal government consumer protection advances through the decades. One thing that we've done with our air standards is auto manufacturers now build their cars to the highest standards. So we set the pace, and then the vehicle sold in Oklahoma or Kentucky has the same protections because they're not going to manufacture different cars. Is there any movement towards other states adopting what we've done, and or where are we at with federal government looking at this?
So I've been to Washington a couple of times to talk to various members about it. I think it's not lost on anyone that 20% of the House majority is from this state, including some important committee chairs. And what I've heard from everybody thus far there is that a bill to preempt California with a weaker standard won't happen. They won't let it happen. You know, I think there's plenty of national example. For example, HIPAA, the health law, GLBA, Gramm-Leach-Bliley, the financial law, are both what they call floors, not ceilings. They set national standards, but they let the states go beyond, and I think that's an appropriate thing to do here. My final point on this is that I think tech is trying to sell this worry that, oh, 50 different standards, we can't possibly comply. And my answer to that is, to the point you just raised, I think it's going to be absolutely untenable for a consumer-facing company on January 2nd next year to say to the residents of New York or Illinois or Texas, hey, by the way, all the people you know and your friends and relatives in California now have rights that you don't have. I don't see how that's going to happen. So I'm not particularly worried about the 50 states thing. And even if there were 50 states, look, there are 50 different data breach laws, and you know what? Business keeps on going.
So a few years ago, I carried legislation unsuccessfully looking at the auto industry. We now have computers on wheels. You buy the vehicle, it's yours, you own it, but it continually is generating data that is used by insurance companies, sold to insurance companies. They can track your routes and know that you go by this Denny's restaurant every day, and then you start getting emails or Facebook postings about Denny's restaurant in Santanella or wherever it may be. So I own the vehicle, I own the computer, but I don't own the right to opt in or opt out or control. Do you know, does this law protect data that's being generated from our vehicles?
Yes, what you'd be able to tell the company is, don't sell my information. Now, they could still collect it for specified purposes, like for warranty, for that kind of thing, for maintenance, for safety, but they couldn't. And by the way, on that, what's really interesting, I know someone in the auto industry who said, you know how often you buy a new car or you lease a new car and they say, oh, be part of like OnStar or something, and then after the 3 months they say, now we'd like to start charging you. Well, what they've started doing now is if you say no, they still keep it on. You know why? Because the data is so much more valuable for them to collect.
Than your monthly fee.
Than your monthly fee. Right. So they offer to do for free.
Thank you. And my final question, Madam Chair, relates to your comment about the BIT device, the application that can allow the owner to track certain health data, but built into that is a connection to a Facebook application, but that doesn't appear anywhere on the bit piece. How does this law protect the consumer from that scenario, or does it?
Well, if you told Fitbit, in this case, not to sell your information, again, we do have these operational, what we call business purposes, where the data can be transferred. But in that case, if Fitbit was relying on a business purpose exception to transfer the data between Fitbit, say, and Facebook, Facebook wouldn't be able to combine that data with everything else it knew about you. So it would only really be able to use that data in the context of Fitbit. And so one way to think about that is you go to the LA Times, Facebook can know about you while you're on the LA Times. You go to the Chronicle, Facebook can know about you on the Chronicle, but it can't combine that. So it can't track you, for the consumer who opts out, it can't track you across every page you visit on the web and combine all that into one giant database.
So, and I said it was my final question, but I actually have one more.
We'll give you one more.
Moving forward, when this law becomes in effect, what about data that's already been collected? Can we go retroactively and say whatever data you collected of mine up to January of 2020 or whenever it goes into effect, do we have the ability to reach back to protect data that they may already possess?
No, we want to draw a line in the sand and sort of give it a standing start, and so it's moving forward from then.
Thank you. Thank you, Madam Chair.
Thank you. Senator Wachowski.
I guess I have a question on your comment on the right to delete. I'm sure consumers like that. The excellent staff report talks about some broad exceptions. There's, security, detection makes sense, debugging, public interest information. Then we have this rather large, the businesses' free speech rights. And all I can think of is that baker with the wedding cake, exerting their right. And I wanted to get your take on that. Is it to make it meaningful for the what I expect, or I think some consumers, of the right to delete my personal information?
So, we live in a country with strong First Amendment rights. And one of the, not answer your question, but to answer it a different way, one of the ways to think about this bill is we give the Attorney General a tremendous ability or power to issue regulations in furtherance of the act. And so my intention was not to set something in stone and then say that's a forever thing, because I think this is moving with the times. And so that's the kind of thing where you could say, okay, this is what the regulation means, and then to the extent that you find it's being abused or that it needs fixing, you could probably fix that with a regulation from the Attorney General enforcing is my hope. I think the reason we put it in there is because I was told that was something you needed to put in terms of being able to not trample on First Amendment rights.
So the way the balancing ball would work is they have my personal information. I ask them to take it out. They say, no, this is a free speech expression. Then I ask the Attorney General to sue for me.
Yeah, I think what would probably happen is multiple people would say, hey, look what companies are doing. They're using this as a loophole. They're saying it's all First Amendment rights, but no one's actually deleting your information, and then that would become a thing. And I think that the Attorney General would step in. Do you have any? Yeah.
Which is, as you note, putting quite a burden on the Attorney General. There is that as well. Any other questions? All right. Thank you.
Senator, I just actually want to correct something. Sorry,
all right.
I was wrong.
Please.
One clarification, the text of the measure applied only to information collected after its effective date. That provision is not in the CCPA enacted by the legislature.
All right, so what would the consequences of that be? Would that mean that we could go back retroactively?
January, you will be able to go back the year. It's a year you can look back a year.
All right, that's very helpful as well. Thank you so much. Really appreciate your testimony and all the hard work you've done. And I know your daughter is sitting here. Your daddy rocks. All right. And I didn't get paid to say that. Okay. Thank you so much, Alistair. All right, our next panel is talking, we're going to compare the CCPA with its counterparts and take a look at compliance. We've asked our three Witnesses, please, 15 minutes each, and then we will, after they have all provided their testimony, open it up for questions. So we have first with us Lydia De La Torre, who is the professor and co-director of the Data Privacy Certificate Program at Santa Clara Law School, followed by Jessica B. Lee, who is a partner and the co-chair of the Privacy, Security, and Data Innovations Department at Loeb & Loeb, LLP. And then our third and final member of this panel is Ariel Fox Johnson, who is senior counsel for the policy and privacy aspect to the Common Sense Media Kids Action Group, which has been very active in the privacy arena as well. So with that, and I have to say, it's always so nice. I have a panel of 3 outstanding women, and I want that to go well noted. And do appreciate all of you being here. And we'll start with Professor De La Torre.
Thank you, Senator Jackson, and members of this committee for giving me the opportunity to participate. My name is Lydia De La Torre, and I am the Privacy Fellow at Santa Clara Law School, where I co-direct the privacy program and teach comparative privacy law. I am licensed to practice law both in Spain and in California, and prior to joining Santa Clara, I worked in the private sector both as an outside counsel and as an in-house privacy attorney. I have been asked to use my time to provide a general overview of what is the GDPR. GDPR stands for General Data Protection Regulation, and is one of the 3 laws that implement the right to data protection in the EU. The other 2 are rarely discussed in the U.S. because they are directed to the public sector and therefore do not affect U.S. organizations. In the EU, the right to data protection is a fundamental right and is right in Article 8 of the Charter, which is the EU functional equivalent to the U.S. Bill of Rights. In addition, the constitutions of some EU countries provide for a right to data protection. For example, Article 18.4 of the Constitution of Spain grants Spaniards a right to data protection. In addition to having a right to data protection, Europeans also have a right to privacy. The right to privacy is protected under Article 7 of the Charter and is recognized by most, if not all, member state constitutions. The only area of privacy regulated in the EU at the EU level is communications privacy. In 2002, the e-Privacy Directive imposed restrictions on collection, access, and use of communications data, and mandated certain security measures. It also established the rules of consent for direct marketing and is therefore the EU counterpart to the US CAN-SPAM Act. The e-Privacy Directive was nicknamed the Cookie Directive because it is the reason why the so-called cookie walls were implemented in EU websites. One helpful analogy to understand the right to data protection in Europe is this. In the same way that US citizens have a constitutional right to bear arms, which is different and distinct from, but connected with, the right to self-defense, Europeans have a right to data protection, which is different and distinct from, yet connected with, the right to privacy. The origin of the right to data protection can be traced back to the rise of automated data processing in the 60s and 70s. At the time, the virtues and risks of what we now call computers were debated on both sides of the Atlantic. In the US, the consensus was that no overarching new regulation was needed. Europeans came to the opposite conclusion and decided to enact a new type of laws. These new laws set out to regulate how computers are allowed to think about humans. The original name given to this new legal field was Protection of Individuals with Regards to Automated Processing of Personal Data. This name was certainly too long and was eventually shortened to Data Protection Law. The Council of Europe, an international organization to which all EU countries belong, play a key role in the development of data protection law. In 1973 and 74, it issued 2 influential resolutions that laid down the data protection processing principles embedded today in GDPR. Most importantly, on January 28 of 1981, the Council opened for signature the Convention for the Protection of Individuals with Regard to Automated Processing of Personal Data, known as Convention 108. This convention is the seed from which the right to data protection is sprouted, and it remains to this day the only international binding agreement in the field of data protection law. Incidentally, it is also the reason why Europeans celebrate Data Protection Day annually on January 28th. The first pan-European data protection law was enacted in 1995 and remained in effect until it was derogated by GDPR in 2016. Its framework was built on 4 core tenets that have proven strong enough to drive effective compliance, yet flexible enough to adapt to the ever-changing nature of technology. These tenets were not changed by GDPR. I will briefly discuss them and offer correlations to CCPA. The first tenet is that technology must be built to serve humankind. In the words of Apple's CEO, technology is capable of doing great things, but it doesn't want to do great things. It doesn't want anything. That part takes all of us. The overarching goal of data protection law, as described in Recital 4 of GDPR, is to ensure that technology is designed to serve mankind. To prevent unethical uses of technology, data protection distinguishes between permissible and non-permissible purposes. EU data protection law identifies 6 categories of purposes called lawful bases that constitute the universe of what is permissible and outlaws the use of digitalized personal data for any purposes that fall outside of those 6 categories. It could be said that the general rule under GDPR is that you are, quote unquote, guilty of unlawful processing until you can prove your innocence by identifying a lawful base. Perhaps the history of Europe best explains this restrictive approach. Although the potential for good in new technologies really did not escape European lawmakers, the question of how the Holocaust will have looked if a database capable of tracking the whereabouts and religion of all European citizens existed at the time was likely not far from their minds either. The CCPA does not adopt GDPR's restrictive general rule, but it does incorporate the idea of purpose limitation. More specifically, CCPA subjects the sharing of personal information for certain purposes, what CCPA calls commercial purposes, to a right to opt out for adults, a right to opt in for minors. In contrast to the GDPR, which does not define the conduct that it restricts, the CCPA defines the conduct, a data cell, that it restricts. The second tenet is that factual control should equal accountability. Under EU data protection law, accountability for data handling is directly proportional to factual control. Any entity that, alone or jointly with others, determines the purposes and means of the processing of personal data is considered a controller. Entities that act on behalf of controllers are considered processors. Because Europeans see data protection as a fundamental right, very few organizations are exempted from GDPR. By limiting the exemptions and equating control and accountability, GDPR effectively creates an unbreakable chain of custody over personal data. CCPA ties control to accountability by incorporating the concept of controller to its definition of business and the concept of processor to its definition of service provider. However, CCPA only applies to entities that meet certain thresholds, which in practice means that significant amounts of personal information will be processed outside of the scope of the CCPA. Therefore, it could be said that the chain of custody over data under CCPA can be interrupted. But since CCPA equates control to accountability, the chain will not break. As data changes hands, whenever an entity that meets the CCPA thresholds acquires effective control over it, their data management practices and those of their service providers will have to comply with CCPA. For example, a data broker that meets the thresholds will be subject to CCPA even if it exclusively collects data from sources that are not subject to CCPA and has no direct relationship with the individuals to whom the data relates. The third tenet of data protection law in Europe is the attitude of regulators, which is, if you can connect it, we will regulate it. The line between private and sensitive and public and harmless is blurry today. Technological advances enable the identification of individuals based on data that, at first glance, seems random, and make it possible to derive sensitive information from relatively mundane data sets. For example, researchers have found 95% of cell phone users can be uniquely identified by using only 4 spatiotemporal points. Those are 4 points identifying their approximate whereabouts at an approximate time. This fluidity has hamstrung legal frameworks that limit their scope to data that is inherently private or sensitive. European data protection law restricts the processing of personal data and defines the term to mean information relating to an identified or identifiable natural person. This definition is rather short, but its scope, as interpreted by European courts and data protection authorities, is extremely broad. Information need not be private or confidential to be subject to the GDPR. In fact, some of the most public things about us, including our name, are also unquestionably personal. Proof of a special interest to prevent dissemination or misuse is not needed, and establishing a reasonable expectation of privacy is not required. Therefore, publicly available data is subject to GDPR so long as it is personal in nature. In the same way, information need not be sensitive to be subject to GDPR. Article 9 of the GDPR places additional restrictions on the processing of information that historically has been a vector for discrimination, such as race, religion, political affiliation, or sexual orientation. These are called special categories. However, there is no minimum threshold of sensitivity below which GDPR does not apply. The definition of personal information under CCPA is more comprehensive than any existing definition under California law. This definition includes in its scope data elements that, in and of themselves, are neither private nor sensitive. Some have argued that CCPA will regulate data not regulated under GDPR. I personally cannot imagine how an interpretation of CCPA could result in that outcome, especially when CCPA excludes data not excluded from GDPR, such as anonymized and aggregated data. The fourth tenet of data protection law is that transparency is the only path to fairness. A key goal of data protection law has always been to enhance the transparency of data processing. Transparency is seen as a prerequisite for fairness because, in many ways, compliance with data protection law is a black box. From granting individuals a right to be informed and a right to access, to requiring the creation and implementation of data management policies, imposing record-keeping obligations, mandating the appointment of data protection officers, and enabling a private right of action, many provisions in GDPR are designed to ensure transparency. The CCPA goes farther than any existing U.S. federal or state law by including transparency-enhancing provisions, and most notably, it gives Californians a right to access their personal information. However, it does not go as far as the GDPR. As a final point, in my experience, the protection of personal data requires the appointment of independent and well-trained professionals to managerial positions and a scheme that effectively protects them when they raise issues internally. The CCPA does not specifically require appointment of individuals responsible for compliance, and California laws today offer no meaningful protections to privacy professionals despite the fact that they often function as embedded regulatory enforcers and not always in friendly territory. It is my belief that empowering and protecting privacy professionals will go a long way towards ensuring effective privacy protections for California residents. In conclusion, in addition to having a right to privacy, Europeans have a right to data protection. The GDPR is one of the 3 data protection laws of the European Union. Its stated goal is to ensure technology is built to serve mankind, and to this end, it allows the use of personal data only for purposes deemed ethical, creates an unbreakable chain of custody over data by equating accountability to factual control, and includes many transparency-enhancing provisions. The CCPA represents an innovative approach to enforcing privacy protections in California, and although it is not modeled after the GDPR, it does incorporate into its mechanics certain elements that have formed the core compliance structure of European data protection law since 1995. I again would like to thank the chairman for this opportunity to participate and look forward to your questions.
Thank you very much. And now we will ask Jessica Lee to talk to us about some of the workability issues. Clearly, the 2 systems are a little bit different. Some of the requirements under GDPR are more stringent, but focusing on how does one go about advising clients about CCPA? Are there things that we could clarify? Are there things that make it difficult to be able to give that advice to clients? Just how, as a practitioner, do you go about advising your clients on how to comply?
Sure. And I'm going to read my prepared statements. I will say I have a list. I won't get through everything in the 15 minutes, but I'll cover the highlights and happy to answer questions after.
And if you could move that closer to you so that we can all be able to pay attention. Thank you.
Yeah. So, Chair Jackson, committee members, my name is Jessica Lee. I co-chair the Privacy, Security, and Data Innovations Practice Group at Loeb & Loeb. In this capacity, I advise clients on compliance across a variety of privacy regulations, including with the EU's General Data Protection Regulation and more recently the California Consumer Privacy Act. I appreciate the opportunity to be here today. I've been asked to speak about my experience helping clients prepare for the GDPR, the steps needed to take to address the CCPA, and then identifying where there are gaps and where there are overlaps. And I'll end by offering some suggestions of clarifications to the CCPA that could help guide compliance and better achieve the goals of this law. Please note that my comments represent my own views and my observations, and I'm not speaking on behalf of any client of Loeb & Loeb. So before I begin, I think it's important to quickly highlight the fundamental differences between regulation in the US and regulation in the EU. The GDPR and the privacy directive that preceded it attempts to codify a baseline of principles designed to protect the rights and freedoms of individuals as they relate to the use of their personal data. The GDPR doesn't tell you exactly how to meet its goals, although it provides some details with respect to its expectations. Instead, it places a burden on companies to be accountable for their own practices. While guidance and enforcement provide some clarity, the regulation itself has many gray areas and room for interpretation. Counseling clients, particularly US-based companies, on compliance with this law is a challenge. In the US, our laws are very prescriptive. We don't just tell you what to do, we dictate it to you. We tend to be very specific. And there are pluses and minuses with this approach. In the plus column, it gives clarity to business. They can say they have checked the boxes, they are compliant, and then can move on with periodic compliance audits. In the minus column, it means that some US laws may be overbroad in some cases or rigid. Privacy law in the US has traditionally been sector specific. So we have laws to address health data, financial data, and children's data as examples. And drafting prescriptive laws in such narrowly tailored contexts are less likely to give rise to unintended consequences. The US has not, however, had a general privacy law that applied across all industries, in part because it's difficult to craft a regulation that is both specific and then operationally manageable across multiple industries and companies of varying size and resources. The GDPR, although frustrating for those used to having a very specific roadmap to compliance, allowed companies flexibility to create their own roadmap within the parameters set out by regulators, by examining their data use practices and then tailoring a compliance program in a manner that balanced their business practices with their privacy obligations. So this doesn't mean that companies were just left to their own devices. You know, some of the past and the enforcement actions over the past few months make that clear, but it does mean that strong privacy protection and regulatory flexibility can go hand in hand. So So I'll speak to what GDPR compliance looks like in practice. A GDPR compliance program can be thought of as having 3 key phases, beginning with discovery. In the discovery phase, companies take stock of their current practices. They work with internal stakeholders, often external vendors, and companies take inventory of the data they collect, the source of the data, how the data is used, who it's shared with internally and externally, where it's stored, and then what security controls are applied. And this involves input from everyone from the business to IT and legal. And it's important to understand that for many companies, data is stored in unstructured formats across multiple databases with a variety of owners. Organizing this information across a company, both for large companies with complicated organizational structures and for small companies as well, is a costly and time-consuming effort. Next, once a company understands their data landscape, it conducts a gap analysis to determine the gaps between their practices and the regulatory requirements. And I'll give you a few key questions that a company will ask itself during this phase. So the first, and this is for GDPR, what is the lawful basis it will rely on for its processing activities? The GDPR requires a company to have a lawful basis for processing data, and there are 6 options, including consent and legitimate interest. It actually isn't a notice and consent regime. You have to get consent to drop a cookie under the e-privacy directive, but for GDPR purposes, there are 6 bases you can look to have a lawful basis for processing your personal data. And consent and legitimate interest are most popular for businesses, and they have their own requirements and consequences. So when a company is relying on consent, it's important to understand if that meets the GDPR's standards. Is it specific? Is it unambiguous? Is it freely given, meaning that there's an actual real choice about whether or not you give consent? And then when a company relies on legitimate interest, a company conducts a 3-part analysis, identifying whether their interest is legitimate, meaning is it lawful, and then whether their use of data is necessary and proportional to the purpose. And finally, whether the risk to the rights and freedoms of the individual are so high that they might outweigh the interest of the business. A company will also ask if it's engaging in any high-risk processing activities. So the GDPR requires a data protection impact assessment for any high-risk processing activities, and that can be activities that involve the collection of sensitive personal data, can be processing on a large scale, or automated decision-making that could have a significant or a legal effect. That could be credit reports, that could be housing determinations, employment determinations, and the like. Companies conduct these assessments, they adjust their data processing activities to reduce the risk to individuals, and they document their findings and conclusions. Again, these require a thoughtful analysis, and a company ultimately has to be able to justify the conclusion that it reaches. And then finally, a company identifies gaps in their internal processes and procedures. So companies assess whether their practices are sufficient to meet the GDPR's requirements. The 3rd phase of a GDPR compliance program is remediation and implementation. This is when companies actually implement the changes required to address the gaps they've identified, including implementing a process to respond to those data subject requests. This is really where the compliance program should go from theoretical to operational. It's one thing to say that you're going to erase a consumer's data, but in order to actually respond to an erasure request, you need a mechanism to verify the consumer. You need to know where the data is stored, whether you have an overriding need to retain the data, and the technical infrastructure to respond and comply within a 30-day period. A few other tasks happen during this phase. You may implement new data security protocols. There's a requirement to maintain a data inventory, and that has to be continually updated. You'll need to train your employees and update your external privacy policies in your consumer-facing language. Companies also need to update their third-party agreements and templates. The GDPR requires companies who control the use of data to place certain obligations on the companies that process data on their behalf. And a good amount of time is actually spent going through those negotiations. There are real commercial implications there. It's important to understand also that GDPR compliance is not a finite project. So while May 25th was characterized as a deadline, it wasn't really a deadline, it was just a marker of time. And compliance with the GDPR ultimately is an ongoing effort. Assessments conducted last year may be out of date for some, records of processing have to be continually updated, and risks need to be continually assessed. It's also important to note that the GDPR for many companies required a shift in their business culture. These regulations are more than just a policy or practice change. For companies that aren't data-first companies, these require huge infrastructure shifts and additional resources to support the compliance effort. So now I'll turn to the CCPA. It's important to keep in mind that the CCPA and the GDPR take a very different approach to privacy and data protection. So while the GDPR is focused on all processing of personal data and requires that lawful basis for processing activities, the CCPA is focused on the collection and transfer of personal data. They each give individuals certain rights over the use of personal data, but they approach those rights differently. So companies who are not subject to the GDPR will need to start from scratch, going through that three-phase process I just described. If a company has implemented a GDPR process or program, it'll be in a stronger position to build a CCPA compliance program. But even those companies who updated their practices to comply with the GDPR, there's still a lot of work to be done between now and 2020. And as we saw with the GDPR, smaller companies with fewer resources may be at a significant disadvantage as they work to meet these new obligations. The challenge for these companies is that they will not be afforded the same flexibility that they may have been given under the GDPR. So in terms of what CCPA compliance will require, again, we'll start with the data inventory and mapping process. Companies who prepared for the GDPR can leverage the work potentially that they did. However, many companies limited their efforts to the EU-facing portions of their business. Even if companies engaged in enterprise-wide assessment, there are questions a company will need to ask itself that it would not have asked going through the GDPR process. So companies need to understand first if they collect information from California residents. The GDPR, in contrast, has no residency requirements. It grants protections to any individual located in the EU. And it's fairly simple to identify, particularly online data, whether or not someone's in the EU based on an IP address. But IP addresses are a proxy for your physical location, not for your residency. So for companies who don't send direct mail, for example, or if you don't deliver products to someone's home, you may only have an email address or an IP address, and that won't convey any information about residency. A company may ironically need to collect more information, such as a mailing address, to determine where a consumer resides. Companies also need to understand if the law applies to them and when. The GDPR, as we talked about earlier, divides the data collecting world into controllers and to processors and allocates responsibility based on the company's role. A controller under GDPR would be the business under CCPA, and a processor under GDPR would be the service provider under the CCPA. However, the CCPA is not as clear about the obligations of a service provider. Due to what to me be just a missing comma from section 1798.140C1, a vendor could be deemed a business under the law merely because it collects consumers' personal information, even though it's only doing so on behalf of a business. This is a point that could be clarified so companies can understand their roles and understand what obligations might apply to them. The inventory process is also impacted by the differences in the definition of personal information. Both the CCPA and the GDPR reflect the concept that data is personal when it can be used to either directly or indirectly identify a person. But the CCPA expands that definition to include household information and information that is capable of being associated with an individual, which ultimately could be anything. Understanding what constitutes personal information is one of the compliance challenges that companies are going through right now. And then finally, companies need to determine whether or not they are selling personal data as defined by the CCPA. And I know many of you have received an earful on the broad definition of sale, so I'm not going to spend a lot of time on that. But I will say that complying with the obligations with respect to the sale of personal information requires a company to understand not only whether they are selling, but they'll also need to determine the value to them of the data being sold. I think as it's written right now, it's a value to the consumer, but that appears to be a typo. There may not be a clear metric for this valuation. Companies also need to understand the consequences of opting out, both on the business and the consumer, and whether the impact on the consumer would be deemed discrimination. These are not only legal decisions, they are business decisions, and they may require companies to reevaluate and change their business models. You've already heard about some of the challenges that are presented for companies with loyalty and membership-based programs. Once a company completes its mapping and assessment phase, it'll need to turn to implementation. For CCPA, this will largely be focused on how to provide and respond to the individual rights. And while the CCPA and GDPR offer a similar set of rights, the CCPA is more prescriptive in how those rights are delivered. I'm just going to focus my time on two. For the right of access, so the laws are fairly similar when it comes to the right of access, but the procedure is different. So while the GDPR requires a controller to provide an easily accessible mechanism to submit data subject requests, the CCPA tells us exactly what that mechanism should be, and that includes providing an 800 number. And while this number itself is fairly easy to obtain, staffing and training telephone operators to respond to requests require additional resources. This is also a challenge for companies who just interact with their consumers online, and may also present risk in terms of verification. With respect to opt-out, both the CCPA and GDPR provide a right for individuals to restrict how a company uses their data in certain cases. So while the GDPR does not specify how this opt-out is made available, the CCPA specifically requires the link, "Do not sell my information," on the home page of the business, which as defined could be every single page of a website, also using language that could be misunderstood or misinterpreted by the average consumer. I think one of the key compliance challenges faced by companies is that there are so many unanswered questions at this point, and the clock is ticking. And I don't think there's any expectation that the fundamental requirements of this law are going to significantly change, but we do know that there'll be rulemaking from the Attorney General. There will likely be additional legislative amendments, and that might impact how the companies operationalize these requirements. You know, take, for example, if a company spends resources now creating a consumer verification program, then rulemaking is issued next year that's contrary to its plan, it may not have time to implement the required changes. Once the GDPR passed, businesses had 2 years to prepare their compliance programs. And while the then Article 29 Working Party issued guidance to help provide clarity on some of the gray areas, it was just that. It was rulemaking that could require, it was just guidance. During the 2-year ramp-up, there was no additional changes in the law itself or rulemaking that could require a change in direction at the last minute. So while companies I've advised are starting the mapping process now, they actually need to begin operationalizing fairly quickly in order to meet the 2020 deadline. So I'll spend my remaining time discussing a few modifications to the CCPA that could clarify some of the compliance obligations and reduce the risk of unintended consequences. And the companies I advise recognize the need for these protections. I want to emphasize that. They're just struggling with how. So first, while it's received a lot of attention, it was mentioned earlier, I do want to underscore the desire for clarity around the inclusion of household in the definition of personal information. The way that it's incorporated now creates a real risk that data could end up in the hands of the wrong individual. There appears to be nothing in the statute preventing a roommate, for example, from exercising a deletion request just as a prank. Less innocuously, an estranged husband could exercise a data request and get information about his wife and children. A legislative amendment to remove the reference to household and the definition of personal information could prevent some of these unwarranted data disclosures without watering down the law because the definition is already very broad. Alternatively, a narrower solution could be to amend the law to specify that there's no obligation to provide a consumer with the personal information of any other individual, even if that other individual is a member of the household. Either approach would help ensure businesses are able to effectively comply with this law. Second, you might consider introducing the opportunity to create codes of conduct. This is reflected in Article 44, I believe, of the GDPR. As I mentioned at the top of my remarks, creating a privacy law that applies across multiple industries and businesses of varying sizes is a challenge. Codes of conduct, which would be reviewed and approved by the legislature or Attorney General's office, would allow for additional clarity that would take into account specific features of certain sectors and the needs of smaller companies. Finally, there is confusion about the 12-month look-back period and when exactly it will begin. Businesses need time to map and organize their data. I spoke earlier about the fact that data could be in multiple databases, very unstructured. It's a process to kind of bring this data into a place where you can effectively honor these data subject requests. It's not that it can't be done, but it is something that takes time. And so rulemaking that could provide some clarification that if the rules aren't published until next year, that really leaves very little time to map and organize that data according to the final definition of personal information, again, which might change according to rulemaking. So an amendment that clarifies that 12-month look-back period will not begin until the publication of the Attorney General's final rules, or at least allowing some sort of grace period for compliance following the publication of that rules, would allow businesses to update their practices. I'd just like to close by saying that my comments are designed to help inform the committee on challenges that businesses, good actors in most cases who want to follow the rules, will face in trying to implement the CCPA's requirements. And I appreciate the opportunity to provide these comments. As I said, I think there are a number of other places that where we could use clarity to help businesses implement, but I have a short period of time, and so I'll conclude here and I can answer any questions you might have.
Thank you very much. Appreciate that from the perspective of the practitioner, how do you advise companies how to comply? And I'm sure there'll be questions as we go forward. We're going to conclude this panel with comments from Ariel Fox Johnson, Senior Counsel with the Policy and Privacy on Common Sense, with Common Sense Media and Kids Action. Again, if you could provide us that information in about 15 minutes, and then we will open it up, this panel up to members of the committee. Thank you for being here.
Thank you. Good afternoon. My name is Ariel Fox Johnson, and I represent the National Kids and Families Organization Common Sense Media, which was a co-sponsor of the CCPA. I wanted to thank the committee, Madam Chair, and the Vice Chair for this important hearing and for inviting me to speak today. Common Sense has over 108 million users, and our educational materials are used in half of U.S. schools, including by almost 80,000 California teachers. We have a long history of sponsoring and supporting privacy legislation in California, particularly that which protects families, children, and students, such as California's landmark SOPIPA and last year's CCPA. We also work in states across the country, many of whom are calling after the CCPA, as well as with the federal government, to ensure that young people's privacy is protected. And one of the best ways we see to protect young people's privacy is to protect everyone's privacy. Young people are the most surveilled and tracked generation ever. Their personal information, activities, hobbies, and networks are exposed from birth, and these activities are for sale. Young people will spend their entire lives connected in order to get an education and to participate in modern society. All of this data makes them uniquely valuable to companies and uniquely vulnerable to privacy harms. While access to powerful technology from early on gives kids access to new opportunities, it also means devices at home, at school, and everywhere in between are constantly tracking them. And these devices can usually be cheap and insecure, particularly when we're talking about a young kid's toy. Millions of kids and parents have had sensitive information, dinner table chats exposed by connected devices, toys, teddy bears, baby cameras. Additionally, as kids' brains are still developing, they lag behind adults in conceptualizing privacy and understanding terms of service and recognizing ads. If you think you have trouble reading a terms of service on your cell phone, give it to a 13-year-old. Their eyesight might be a little better, but they will not be able to comprehend it. Most school-age kids can't even distinguish ads from other content. Kids are prone to sharing and impulsive behavior, and they're less able to understand what happens to their information if they do put it out there. Unfortunately, as a study confirmed, information is collected, sold, and repackaged by data brokers, including for kids as young as 2 years old. And identity theft victims can be, 3 months old, I think is the youngest I've heard of. So Common Sense asked parents across the country how they wanted to protect their privacy rights and what tools they thought would help their families. More than 9 in 10 parents and teens thought it's important that websites clearly label what data they collect and how they will use that data. And the same numbers think it's important that sites ask permission before selling or sharing data. These views inform the values that guided our approach in California. Because at Common Sense, we believe that kids need the freedom to make mistakes, to try new things, and to find their voices, unencumbered by the looming threat of a permanent digital record that could be used against them. Kids, and really all of us, deserve a world in which our daily musings to friends are not assessed by corporations looking to turn a profit or by nefarious actors looking to manipulate our behavior or our democracy. This is a world that the California legislature sought to avoid with CCPA. The CCPA is the first generally applicable consumer privacy law in America. It is not limited to financial or health information or any specific entity, but it recognizes that Americans have privacy rights in all of their information. It compares favorably to other privacy laws, especially in the US, in both moving us out of sector-specific laws, which I think are becoming increasingly outdated as technology is around us and in everything nowadays, and in moving us beyond a notice and consent model. When we look to the GDPR, however, the CCPA could be improved, both in terms of giving consumers additional rights and in terms of small tweaks to ensure that rights already offered are real and able to be exercised by individuals. Professor de la Torre has explained how privacy and data protections are fundamental rights in Europe and how the GDPR supports those rights. In California, the right to privacy is fundamental as well. And it is imperative that laws like the CCPA support it. Article 1, Section 1 of the California Constitution provides that Californians have an inalienable right to pursue and obtain privacy. Also, similar to Europe, California enshrined the right to privacy in the 1970s in response to fears over increased surveillance and data collection by modern technology. So how does the CCPA compare to the GDPR, and where could it be strengthened to ensure it is supporting Californians' inalienable right to privacy? One major distinguishing feature that you've heard about already today between the GDPR and the CCPA is the baseline assumptions about what processing is okay. Under GDPR, the baseline assumption is that a company should not collect, use, sell, or share your information unless they have a lawful basis for doing so. Under the CCPA, the default rule is that it's okay for companies to do what they wish until an individual says no. And then what an individual can say no to is limited to stop the sale of their data. Collection and use, or data minimization, are not covered by the law at all. While the CCPA is a huge step forward for the US, it still falls short of the GDPR in terms of available protections. And it puts the onus for action and for protection onto the consumer, who has to say no. Teasing these concepts out a bit more, first is that the baseline is it's okay for companies to do what they wish with data. Companies have no requirements to build in privacy by design or to practice data minimization. The burden is on the individual to object. And a point about that objecting. We've heard that one of the more prescriptive things in the California law is that there is this do not sell link. One, do not sell was chosen because it should be pretty clear to a consumer what it means. I'm not sure if there's a more clear way to state that. But two, the reason that it has to say do not sell and it has to be so prescriptive in that case is because the burden is on the individual. You want to make it as easy as possible for them to exercise this right. If companies wanted to make the burden on them to not do anything until an individual said it was okay, then you wouldn't have to have this prescriptive do not sell requirement. But since the onus is on the individual, you want to make it as easy as possible to exercise that. So this is different from the GDPR. Additionally, as I mentioned, the right to object is not for collection or use, but only for sale. While sell is intended to be broadly defined to cover situations where companies are sharing data or offering access to data in exchange for other valuable consideration, a company's purely internal use of information is not touched by the CCPA. And I think it's important that sell be defined broadly because you don't want a situation where a company is saying, oh, I don't sell data because I'm just sharing access to it in exchange for something else. That seems like sale. In discussing defaults, I would be remiss in not noting a critical place where the CCPA does offer important default protections, and that is for young people. In this way, the CCPA is like the GDPR, both in terms of a protective default and in terms of recognizing the unique vulnerability of minors. If you're under 16, you or a parent, if you're under 13, has to opt in before your data can be sold to a third party in California. GDPR also offers heightened protections for young people, including a mechanism for parental consent for young children. In the GDPR, anyone under 18 is recognized as a vulnerable population. Another place where CCPA and GDPR are the same is in broadly defining personal information. I think we've heard both CCPA is broader, GDPR is broader. I think they're both pretty broad definitions of personal information. So for decades, California Civil Code has defined personal information as any information that identifies, relates to, describes, or is capable of being associated with us. The CCPA continues in this tradition, and it provides a number of examples of things that personal information could include, like unique identifiers. This is, after all, how many companies identify us and put us into various advertising and other market sectors. GDPR similarly defines personal data as any information relating to an identified or identifiable natural person. And that is a person who can be identified directly or indirectly. GDPR also includes online identifiers. Given that companies can tell if we are pregnant not only from what we input into our apps, but from the heart rate that our Fitbit is tracking on us, to our purchases at Target, where they can tell whether you've been laid off based on your energy usage pattern changes or when you're watching TV, a broad definition of personal information that should be protected makes sense. All of that information is deserving of protection. And one point with respect to personal information and household. Well, I think the Attorney General has a very important role in looking at how household is defined and how that works in terms of exercising different requests. For example, I have less of a concern that my roommate is going to opt me out of information selling somewhere, and that would be a terrible detriment to me. It is important that we cover households because that is how companies profile families and kids. There was a time when companies said that a telephone number was not personal information because it wasn't linked to an individual, it was linked to the family home. We don't want the same to be true for smart TVs and for thermostats. So we need to think of a way to include household and to include it smartly. So while the CCPA does have this broad definition of personal information, it does not extend data security requirements to all of this information. And to this extent, it does not go as far as the GDPR. CCPA's data breach provisions only cover a narrow swath of personal information, largely cabined to financial, medical, social security type information. So intimate conversations between a parent and a child over mental health concern, homework, bullying, a video recording from a bedroom, if that was breached, you don't have a right under the CCPA. The narrowness of this data security and breach provision requirement is interesting because the breach provisions has drawn a lot of attention, presumably because that's where the private right of action is attached. And Mr. McTaggart explained how if there's a negligent breach, there's this private right of action. So this brings me to a final way that the CCPA falls short in comparison to the GDPR for consumers, and that is in enforcement. The CCPA does have this private right of action, but it's only for negligent data security breaches. The GDPR has a private right of action across the board. It allows for individuals to bring claims, including for non-material damages like harm and distress. It allows advocacy groups to bring actions on behalf of consumers. And it has serious financial penalties. Indeed, these penalties are much of what made companies sit up and comply, because a number of GDPR requirements existed previously, but there was no real financial deterrence. So the CCPA, with its very limited private right of action, may not serve the same deterrent function as the GDPR. And if companies aren't deterred, then consumers will not enjoy real protections under the law. Consumers are not alone here in wanting more protections. The Attorney General, who's tasked with enforcing this law, in addition to implementing regulations, has stated concerns about resources and has asked that a private right of action be expanded. While the CCPA does represent a new law for companies, though I would note it does not apply to all companies, unlike the GDPR, or even all entities like nonprofits and governments. There is a carve-out for small businesses. It contains many similar provisions to the GDPR, and as I've discussed, it does not have all of them, including various bureaucratic and record-keeping requirements. While I wouldn't ask to have all of those brought to the US, I would support Professor De La Torre's interest in having dedicated and trained privacy professionals to ensure that consumers are protected, though I don't think that's the sort of thing that you want to write in or need to write into a US